Hey, y'all. Yeah. And y'all, we back on our Black Friday non-stop content. Oh, yeah, I wasn't playing. Yeah. So I'm going to be napping and capping and napping and capping and napping and capping. So make sure you like, share, and subscribe if you haven't. And I want to thank those people who did their membership. And y'all get y'all membership too now. And y'all, we back with another reaction. We've been talking about that Takaya Young's indictment. Okay. Remember, Takaya was the young lady that went hard in the handicap spot, went into Kroger, suspected of stealing alcohol in front of people, and walked directly out the store. So at that time, y'all, she made a decision to get in her car, and then she dealt with she was going to deal with the consequences. But the officer took his position to stand in front of her car as if that was a threat. I thought I saw it differently, but the jury saw it differently as well. But I didn't really agree with the indictment, but I think that prosecutors enforce their impact on what really happened in that body cam video. Okay, and y'all, and that is just my opinion about what I saw and what I be seeing in these contents. Okay, not necessarily based on facts or knowledge. Okay, so I appreciate it. Y'all go ahead on like video, and it can help engage with the boost of the video visibility with the platform algorithm. Okay, now what you're going to listen to now, you're going to listen to Takaya Young, grandmother. She stands on business to the officer's indictment. So you'll get a chance to hear her grandmother side. And people, you know what I think about? The older people are there for you. The mothers stand beside you regardless, of what if you're right and you're wrong, but they're gonna stand by you. But we're not here from the grandmother, y'all. I just want to tell the young millennium to take life serious. When you get out of high school, it is nothing like it was when you was in high school. When you hit that, when you jump over that broomstick and you jump into 20s, you jump into years. You're not a teenager no more. You're not a child no more. You're not 8 years old, and you're not a teenager anymore. Now you are the adults, and the crime do not time and the crime don't change for you. Okay, you don't run nothing. So let's go ahead on. I want to get a shout out to everybody. Okay, now y'all, like I said, this is Black Friday non-stop content. And then what we're going to do, we're going to content. Okay, so let's go ahead on and watch video. Okay. Thank you, DJ. DJ Grandma. Yeah, I don't pay me no attention. I'm just a fun person to be around. Yes, sir. Okay. Here we go. I'm going to let the grandmama talk first before I react on my opinion. Okay, this is the grandmother, Takaya grandma, the Takaya young grandmother here with her family attorney. Okay, enjoy the video, y'all. Stop stressing and enjoy the video.
I think we're seeing here is a systemic issue where we have an officer who is now indicted for murder. Um, let's first talk about the fact that Linden Township rushed to call Connor Brothers partner victims. I think that it villainizes people in a way that is cruel. We saw from the video that Takaya was a victim here, and so to use just the narrative that they could invoke Marcy's law. I think that shows that there are already fallacies in any internal investigation because from the beginning, before there was any investigation, they had no problem indicating that from their belief, despite what all of our eyes saw, that there was some way that the Connor Grove was a victim. So I think that he should be terminated immediately. I think there should not be any internal investigation. I think to the point that there is an internal investigation, that speaks to systemic issues within Linden Township. And I think that's where, we're looking at investigating Linden Township from a standpoint. Looking at what practices led to this incident occurring. We know that Connor Grubb, he's someone who, based on our investigation, has had some issues in the past with aggression. We believe that he saw time in combat. And, I think officers deserve better than whatever culture is being created over at Linden Township and other police departments. So he should be terminated. There shouldn't be any internal investigation aside from looking at their own practices and policies and seeing how to make sure that this does not happen again in the future.
We talked months ago about kind of that crucial moment of the car starts moving and Connor Grubb's right there and his feet come off the ground and he fires a fatal shot. That's where the bridge in the road seems to go about how people characterize it. Police are saying, see, she was moving toward him, she was assaulting him. With her vehicle was justified, the use of force response. You see it a different way, I think. Could you just elaborate on that? Not to get too far in the weeds, but that does seem to be the key point in the whole incident.
Yeah, absolutely. And I think what is important to remember is that it's not just how I see it, it's how a grand jury saw it, it's how prosecutors presented it. I assume that based on the evidence they presented, they felt that there was evidence to indicate that a murder occurred here. And, as we backtrack, let's talk about the fact that Connor Grubb pulled his gun out to begin with. Because when he pulled that gun out, when I say comply or die, that's what that looks like. He pulled his gun out and he said, get out the car. He said, get the F out the car to her.
She turned her car to the right, and he jumped in front of that car, jumped on the car, and shot her. Watch the video. I watched it, and I read
she did not follow his commands. His commands were to get out of the vehicle. That's not proper policing in America. It does not respect the constitutional rights of Americans in this country, and it's not what any reason. It's not what any officer who is reasonable would do in those circumstances. So, we look at the split seconds of the car barely moving and his feet leaving the ground. I think that is where the trial will play out. The trial will play out, and we'll get some answers as to legally how the prosecution feels about that. But what I will say is that those split seconds are how officers tend to get away with murder, is to get us caught up in that narrow split second decision, and even saying that he had no choice. He did have a choice. He should have never pulled the gun out to begin with. He should have not stepped to the path of the vehicle. When he saw that Takaya was scared, asking if he was going to shoot her, cops are trained to communicate with people and to de-escalate situations. Everything he did escalated that situation, and that's why Takaya was murdered. It's not because she did anything to warrant that murder. And I think as we split hairs over those seconds, I think that is where we lose the broader conversation that the gun should have never come out to begin with, and he should have taken so many other steps to prevent this, and that is the conversation. So, I think that these charges are warranted. I have my thoughts on those seconds, and I think within those split seconds, it's still very warranted. But aside from that, it should have never happened to begin with.
Why would what? She doesn't around to ask. Why do either of you think she was moving the car? She was scared of him
that gun. He put the gun on her and put it in her face. And that made her scared. She was scared of him and that gun. He put the gun on her, told her to get out the car. And she turned around and said somebody else in the store, it wasn't me. And he told her 2 more times to get out the car. She said, "Are you going to shoot me?" And she cruised real slow in that car, turned to the right, away from him. And then he still jumped in front of the car, jumped on the car, and shot her.
So it's hard to say exactly what she intended to do, but you look at the actions there. Before the car ever moved, she turned it all the way away from Connor Grubb, and her intent was not to hit him or hurt him. And if you look at the video, he actually moves back in front of the car as she turns it away, takes a step back towards the recenter himself. So, shoot her.
Tuning in. But I agree with what the attorney said right here. I seen him move back. I seen him get in front of the car, and then I seen him kind of move back when she was, when she continued to move with the car. A common sense would have said, "Move out the way. Don't stand in front of the car." Or either when the car moved, I would have moved in the way. But it looked like he was like trigger happy. I'm not. I'm just my opinion. Now, I want y'all to know that this Ohio officer was found not guilty of murder in Takaya Young, but he did murder. he did murder her. He did murder her. Now, what Takaya grandmother is doing right here, Takaya Young family is obtaining a statement by the ABC News and Friday say that they will pursue a civil lawsuit, but did not specific when or who the suit will be against. Now they mentioned that the civil cases will prove what the jury could not find beyond a reasonable doubt. The family said in their statement. That's what's going on right now. Okay, y'all, let's go back to the video.
Intent was they may have to shoot her. For what purpose was it? I mean, the car wasn't moving at the point when the gun came out. And again, I think that's why we're here, is that he did not follow proper policing procedures. I think just from a cultural competency standpoint, it is understandable that if a gun is pointed at you and you are in fight or flight mode, that you may cultural competency standpoint, Connor Brooks should have known better.
Okay, what I want to do right here, I want to go back to. I want to show y'all. I want y'all to listen to the. I want to. I'm coming back right here, but I really want y'all to listen to the closing argument, and let's see did the prosecutors put on their best dress. Okay, let's see who put on the cape, the robe, the king, and the crown. Let's see who did that. So I'm gonna let y'all revisit the Takaya's closing argument. God, I can't see. Let me see. Hold on, y'all. See, I'm scared to move this thing right now. Oh, let me see. Yeah, but I don't know why y'all lay up under me like that. Let me see. Takaya. I can't see behind the thing. Closing. Here we go. Okay, now that's the open. I want to see the closing. Okay, this is what I want y'all to hear. Let's see. Here's the closing. Okay. Oh, why they ain't showing it? Let's see. Hold on, let me move this. I'm so scared to move this guy. When I move that right there, let's put Connor Grub. Okay, that's what I want y'all to listen to. That's what I want y'all to listen to. Okay, and then we'll go back to.
My energy bill dropped from $150 to $50 by doing this.
Then we'll go back to what
My
the
friends
grandma
laughed
was
at me
saying.
when I spent $49.
They all indicated, ladies and gentlemen, that that's how it works. You have a split decision there. I submit their witnesses were reasonable police officers and are reasonable police officers. Sergeant Moynihan, ladies and gentlemen, let's talk about him for a second. There's a man who served his country in the Air Force honorably. 9/11, he goes now goes along
How long ago? I gotta make sure I'm in the right place. Okay, here you go. Yeah, I want to make sure y'all can.
Candidates testify sometimes they don't. Again, that's a shiny object. That's a distraction. It's whether or not Kevin Davis trains in Ohio, whether or not Kevin Davis trained cadets in Ohio, police officers in Ohio, because Ohio has different curriculum than other states, and that's the difference between Seth Stone and Mr. Davis. It's not about where you testify; it's about where you train people. What a reasonable officer believed the need to use deadly force if a 3,500-pound vehicle was coming at them and hit them. They learned what is right. They learned what is expected of them. They learned that from the people training them. So when Sergeant Moynihan, who again we call, they didn't call, he's the person with the most interaction with Miss Young in the entire case. And they don't call him in their case. They don't want to hear what he had to say. We had to call him. And what does he say about the tactical position that Connor Brown took? What did he say? He said, quote, it was an effective position. An effective position, okay? Based on where Sergeant Moynihan was on the side. He said, would you go to the side? No. What are you going to do there? I'm already there. Other side? No. Crossfire. Behind? No, you can't see anything. Based on the position he took, that was an effective position. So Colonel Rutherford said that, Officer Sleepy said that, Officer Ferguson said that. They all said the exact same thing. And that's their witnesses. But they don't want you to believe those witnesses that that's a good tactic. Because the professor said that's not. Okay? That's the issue of the case. Officers up. And he sort of said, well, that's a fine tactic. Yeah, another tactic? Sure. Is that effective tactic? Yes. Do they know why Connor Brook took that position? Yes. They told you why Connor took that position. What was your purpose and reason for standing in front of the vehicle? I positioned myself in front of the vehicle for 3 reasons. First, to convey to Young to the fact that things not really the same. Effective, and all of you said that that's appropriate. All right? Second, to provide cover to Sergeant Moynihan as he was positioned on the driver's side of the vehicle and Young was in the driver's seat. Okay? So tactically, now you can see if there's an issue with the lethal fire. Unfortunately, ladies and gentlemen, they have to do these things in their mind when they coach cars. They have to start from the premise that something bad is going to happen. That's how they're trained. They have to try to anticipate situations. So that's why it takes the position. Alright? I did not notice yet access point. And third, with Sergeant Moynihan on the driver's side, the female on the passenger side, as well as the civilians in the busy parking lot, the front of the vehicle is the best position from a tactical standpoint to avoid crossfire. Is it the only position? No. That's the position he took. And the sergeant who trained him said it was fine. The lieutenant who's in charge said it was appropriate, as well as other officers, as well as Kevin Davis. The only person who did was Professor. If a training officer is responsible for giving guidance to other officers below him, and they say it's a proper position, who is a witness, an opinion witness? You see that? No. But that's what they want you to do, ladies and gentlemen. They want you to supersede the people who are on the street every day, who continue to be trained, who go through the process, who deal with society. They want you not to listen to them, listen to a person from the academic scholar, a policing scholar, an intelligent academic reviewer. All of them said, ladies and gentlemen, that it was reasonable to take that position. Next, ladies and gentlemen, another grand factor we have to talk about is a perceived threat. So let's walk through the analysis of is it going to be a perceived threat? Okay. So how do we do that? All right. Can a car be a perceived threat?
the stationary cars, as you indicated on the wreck, that the car moved towards the Connor Road, correct? Yes. A car coming towards someone is no longer not a threat or perceived threat. It can be an actual threat, correct, sir? Sure.
One of the saddest cases I dealt with personally, I have the worst stories.
Their expert agreeing that can a car be a deadly threat? Who else? Officer Fergus, Officer Shigley, Dr. Bauer, Professor Consultant, we call weighing in, and Kevin Davis as well as Jeffrey DeMille. Okay? It's not rocket science, ladies and gentlemen. Okay. Absolutely. 3,500, 3,600 pound car can come towards you and give you a risk of serious physical harm. So now an analysis. Could a reasonable officer in Connor Grubb's shoes believe the car moving towards them is a deadly weapon? Based on Connor's words and their own expert, yes. Can a reasonable officer believe that a car moving towards them is a pre-threat? Yes. They put Connor's testimony in and Dr. Ball said that. Okay? Now, let's talk the next. The perceived threat becoming an actual threat. That's the logical next part analysis, right? Okay, I have a perceived threat. It becomes an actual threat, ladies and gentlemen, when there's contact. Okay? So, the issue is, did the car hit Connor? Okay. Instead of complying, she accelerated the car towards me. I tried to move to the right, please, to avoid being struck with the front bumper of the car, hit my legs and shins. But their professional second guessers can never concede that point because that blows up their whole theory case. Right? What else do you see? Their evidence. Special Agent Douglas, lead agent of the elite team, after watching everything report, he wrote, rapid accelerate and struck the vehicle. Or struck the officer, I'm sorry. Rapid accelerate and struck the officer. Giebler. Again in his report, the car hit the police officer. Bauer, under oath, on September 30th, agreed, yes, both feet were off the ground at one point. Obviously, it had to come from the car. All right, and again on the 11th, he testified here November 14th, he said the same thing. But that's now they realize, oh, if we see that to the jury, I got a problem. We'll get to it, but if I say that to the jury, why? What did he say, ladies and gentlemen? Remember, he's standing right here. You don't think you said contacted him on September 30th? Well, it was more of an interaction. An interaction, remember that? I responded, interact with people. You don't interact with the car. Interaction, you hook it up, interrelate, interchange, interconnect. Synonyms of interact are communicated, engaged, collaborate, cooperated, synergy. Do you really think there was synergy between that car and Connor Road that day? You really think there was collaboration, ladies and gentlemen? But that's the word their expertise is. Because they can't see that point. That's what makes them biased. You really think that that's what happened? And ladies and gentlemen, everybody, witnesses get paid. The difference is your tax money pays for theirs. And you should be insulted with their testimony. Your taxpayers pay for theirs. That's what Dr. Bauer wants you to think, that there was an interaction or synergy. That's an example, ladies and gentlemen, of the government doesn't want you to use your own eyes. They don't want you to use your own ears. They want you not to even use your common sense. But listen to Bauer and listen to the professor on that. No, you heard when Stevens asked him whether or not the car got hit. He goes, I can't say that with a reasonable degree, my level, all that type of stuff. And the other guy said, I'd have to go back to the someone says you have to step into someone's shoes at the scene. Here, ladies and gentlemen, you have to jump into his shoes because his feet are on the ground. And that was shown to you. You don't step in them, you have to jump into them. And you're going to have to do it after you've been hit by a car, ladies and gentlemen. After you've been hit by a car. Interaction versus common sense. Ladies and gentlemen, we have proven more likely than not that absolutely he had a subjective belief of threat of potential serious physical injury. Not the actual injury, a potential serious injury. What else do we have to prove, ladies and gentlemen? More likely than not, the gram factors. And we have proven each of those gram factors to be more likely than not that it was reasonable. Let's go to opinion witnesses. Conspiracy curious question. Curious. Get one name. It's pretty straightforward that Dr. Bauer and Mr. Davis need to proofread their reports before they send them. You miss a parking spot, you miss a name, yeah. Proofread your stuff. But Dr. Bauer, ladies and gentlemen, why? Why the resistance to the answer of the questions asked? Why? How many hours did you work? I couldn't possibly tell you that. Why? Of course you do. How many hours? I don't know, 10 hours? Maybe more 20? I don't know, 30? Why? Okay. Did you submit those? Yeah, I submitted those. How much have you submitted so far? He's not going to tell you. Why not? You're already like, compare that to your common sense. Which one of you has to submit a bill and not know how much? If I owe someone here, here's the number of the bill. It's not complicated. But you can't get the information, ladies and gentlemen. No wordplay, no wordplay. Interact. The hood of the car. Get to the hood of the car. Hours. Okay, 30 plus. There's 30 clocks there, right? I know what's the other time there, right? Can I talk to them about looking at the video back and forth, slowing it down, right? Okay, so whatever time he got home yesterday, he didn't get paid until he gets home at 5, whether the plane gets delayed or whatever. So 40 plus hours, right? That's the time they had to look at this stuff. That's the time they had to come up with a decision to testify to. That's the time. How much time did Connor have to react to a situation? 1.66 seconds from the time the car moved towards him to the time he fired his weapon. That's 1.66 seconds. That's the time. Connor doesn't get to go back and look at the tape. Connor doesn't go, hey, wait a minute. Hey, what's going on here? Can you comply or no? Do I need to get out of the way of the car? That doesn't happen. That's not how life is when you're an officer. You leave every day and you leave your house and you leave your family knowing you might not come home. That's what they're trained with, ladies and gentlemen. That's the starting point.
Are you looking for the perfect egg donor?
Wordplay. What? These hands up over that again with Dr. Bauer. Dr. Bauer is the left hand. You're the center of the hood. No. Is it to the left? Well, here's to the right now. Okay. I can't say that's the center. Is it to the right or the center? You all saw the picture. But he can't get that up because if he gives that up, that means that the car is out. Okay. So he can't get that up. What did he say? I can look back on the tape. There might be some pixel distortion. That's terrorist. There might be some pixel distortion when I ask a basic simple question, and you can read me in the answer to the center of the book. Why? Ladies and gentlemen, why? You know why? It's not complicated. The government started from the premise. They started with Seth Stone testifying at grand jury, the initial point of potential charge. And that person testified at grand jury, and they came to Dr. Desmula. Okay? Fascinating. Fascinating when I asked him, should I call you Jeffrey or not? Please call me Jeffrey. That guy had 2 doctorate degrees, not just one in biomechanics and kinesiology. He has another one in engineering. 2 doctors. No, call me Jeffrey. Okay? What did we ask him to do? Pretty, this is a pretty intellectually hard thing we asked to see. Hey, did Connor have time to get out of the way? You already know that he didn't because he got hit. Okay? But what does Dr. Desmula do? Or Jeffrey do? He takes math, he takes studies, and he compares them, and he does it to the synchronization of the evidence that he's reviewing. Okay? What did he do? What did he synchronize, ladies and gentlemen? Okay? What did he synchronize? Okay. He took the 4 cameras and found contact points. The different people stepping into the shadow of the young person pushing the cart right near the area. He synced those up. And he synced them up with the audio for both body work cameras. So those are the different lines. The bottom is he synced up, get out of the car. The black is you make those. Okay? Now what's important here, ladies and gentlemen, is he was asked, well, did you start your analysis in 10 seconds? The time when Connor wrote contact on the hand was 2.5 seconds before the shot. Okay? The next one, the vehicle starts moving. Remember, that was continuous movement. Continuous movement. Because the car had started and stopped. So he didn't start from then. He started from when he put his hand on that hood, and then there was continuous movement. And then there was body impact. They didn't ask him for your shirt. He didn't think it was an issue. And he actually said that was contesting that the car contacted him. It was like your moment. And so then it was 1.6 seconds, ladies and gentlemen, from the time of impact until the shot. And then remember when he depressed the left hand of the hood. You see the depression go down in the hood. So that was 0.8 seconds. So that's the timeline you work with. Sure, you could go back to 10 seconds, but it's not relevant. Sure, you could go back to a minute and half where he was before that, but it's not relevant. And that's what he told you. So what does he do at that point, ladies and gentlemen? Well, he synchronizes the videos. And what does this video show, ladies and gentlemen? Remember this one? Okay? You look at the time thing up top. This is the time for when the car started the continuous movement until it hit Connor Brown. Now he's slowing it down frame by frame. Okay? He's slowing it down frame by frame. What's the body? Now, they claimed he stepped forward. Dr. Desmula, Jeffrey, said, look, he said, the way the body's constructed, the way they're connected, because there was force down here, that's why you see this going forward, but the other part going back. This going forward, but the other part going back, because that's how the biomechanics work with the body. Okay? So, he had to determine a time of contact from the first continual use of force. Okay, so we have roughly 0.47 seconds. Everybody with me? Okay. So then, he just used math, ladies and gentlemen. He just used math. Okay? There was a study. Just turn it over to them. The footnote, very expert. In the study, they did young people and the time that they can take a step. Okay? In that study, they said the time that someone can lift their step to take it, okay, was 0.53 seconds. It's not a step forward because he said that wouldn't apply here because he didn't step forward, the body got hit. It's not a step backward because he wouldn't fall or trip. So that's why they did it to the side. And a young person, a big young person, it was 0.53 seconds to do that. Okay? Now, what you do in that situation, you have to know from the center line of the car, that's why I asked the question, center line of the car to the end of the right side of the vehicle was 91 centimeters. And this chart showed, in order to move 91 centimeters, you have to take 2 steps. 1, 2 to get out of the way. Okay? And you have to do that within 0.47 seconds. What's harder? 0.47 or 0.53? That's 1 step. What's harder? 0.47 or 0.53 times 2, which is 1.06. 1.06. So mathematically and physically, with video, he serious physical injury from being hit on a car or being carried on a car, moved by a car, and stuff like this. Yes. Okay. You got the chart. Now, again, distraction. That car can go from 0 to 20 miles an hour in 1.8 seconds. And that fits in the timelines here. Is he saying it went 20 miles an hour? No. No one's saying that. But at 20, it could be this type of injury. At 15, you did it 10, 6, 4, all the way down. And even at the least amount, ladies and gentlemen, that car could run over his foot. That car could be tripped enough so it can cause serious physical injury. But how else do we know that? In a practical, everyday sense. So that's math videos and studies. Let's apply the practical sense. Who'd you hear from that we called? Sergeant Whitehead. What Sergeant Whitehead tell you? Hey, yes, unfortunately, I know that a car caused serious physical injury because I was on my thing and I wanted to take a turn. I went through a crosswalk and I bumped somebody in a crosswalk. How fast were you going? I think it was going between about 8 to 12 miles an hour. And he was out. I found out the person had a fractured leg. I was worried about the head because the person got knocked over in the head. But so again, you know that. Practical stuff from a reasonable officer who tells you, yeah, I bumped into somebody and caused serious physical injury. It's common sense, ladies and gentlemen. Other opinion witnesses. Let's go to the Kevin Davis. He's not been testifying where it's years in law enforcement. He has done every single thing that you can do in law enforcement. He has trained. He has been heads of things, different divisions. But more importantly, he's trained at Opana and he trained at different places across the state of Ohio. He told you how many times he consulted. Most importantly, he told you he's testified for officers and against officers. He's turned us down when we've said any use of force. He's testified against both, for and against. I think it's hard for him to testify against an officer and say it's not a good use of force. He's simply the perfect honest. And he told you under oath he testified for officers in trial and against officers. He's told you how many things. But the most important thing he told you is known as the Graham factors because he's required to. He's required to go over those. Seth Stone doesn't believe he's required to go over those. Seth Stone, a part-time law enforcement officer, a total of 5 years, who says, I'm a legal scholar, I'm a policing scholar, I'm an academic scholar, okay? He's never trained any law enforcement officers in Ohio. And the prosecutor said, do you train people now? And his first answer was, yeah, I don't train line officers anymore, I train management. Management is like Kevin Rutherford and Sergeant Whitehead, because those are the people that have to review and discipline officers, okay? Discipline officers, right? So that's what they train. That's what he trains. He doesn't train on line officers. That means everyday training people who come into contact with society. And they just said no. Stoughton said no. Bias? We'll get to the bias, ladies and gentlemen. That's easy in this case. When you compare the professor to Kevin Davis' experience in training and use of force, it does bring to mind the review of the professor. Those who can do and do the job, do the job. Those that can't do the job and choose to leave law enforcement and go into academia, they teach. Okay? They teach. That's Seth Stoughton. Kevin Davis lived it, experienced it, learned it, trained it, and kept going. That's the person they had testified a grand jury. You heard about grand jury. There's no judge. There's no defense attorneys. There's no common ground. There's no anything. They control everything that happens in the grand jury. The burden of proof. The most probable cause. That's how we're here, ladies and gentlemen. The biggest hypocritical situation is that it contradicts, ladies and gentlemen, what the law is. He sat there and told you, Miss Stevens asked him, you're aware of state v. White. State v. White is a case that allows criminal cases in Ohio and random factors to be applied, and they have to be applied. And she put the footnote up there, and the footnote said, yes, you cannot use tactics that say you should have used another tactic. You cannot do that because that's hindsight 2020. That doesn't matter. He contradicts the law. The federal appeals court told him, Ms. Stevens put the thing up there. This court, an appellate court of multiple judges said, your application of the law is incorrect. And his answer was, yes, it was incorrect. That's their witness. No matter what he says, ladies ladies and gentlemen, Carter Rob have the right legally to be there. And you'll never hear anyone argue against that. You won't. You'll hear about policy and taxes. And they don't. The one thing you won't see in the jury instructions is policy. The one thing you won't see in the jury instructions is tactics. That's his phrase. If Professor Stomp wants his theory and his phrases to be used, ladies and gentlemen, then he needs to become a Supreme Court justice. He needs to convince 4 other Supreme Court justices in his way. But until then, he has to follow the law just like he told you guys have to follow the law. It's wordplay, ladies and gentlemen. That's what they do. They twist it and fit it. Wordplay. Let's go over some of the prosecutor's wordplay in the opening. They have this theory that somehow Connor Rowe got his injuries on his shins from falling on the ground. Okay? Ms. Claypool asked the medic, the Polish medic. This is a medic now who trains every day of his life to help people, treat people, think. They call him medic for a reason. Because they give service, they respond to emergencies, and they have to manage them, they have to get him to the hospital, they have to report and stuff like that. And she asked him, could he have gotten those if he fell to the ground? And there was a pause, and he said, man, you don't fall on your shins. Okay, she wasn't expecting that. You don't fall on your shins. Okay, well then, geez, how could they have gotten these injuries? How could you guys, you know what, the glass. We see me on the video, so there must be glass. Must be from the glass. Okay. Well, I asked their expert, Dr. Bauer, where's that picture where he's kneeling? My client's right knee's on there. You see the glass? No. Who was kneeling longer? He or Sergeant Moynihan? Sergeant Moynihan did most of the life-saving measures once they did the time. Okay? And again, it just keeps going and going, ladies and gentlemen. Connor Rowe, you have this back there, blood on the right knee. Close up, blood on the right knee, right? Sergeant Moynihan, blood on the right knee. Blood on the right knee. Both were kneeling in the same area. You'd expect that, right? It's cooperation. It's confirmation. Okay? What's the difference between the two? One got hit by a car and one didn't. So do you really think Connor Rowe is going to get these injuries by falling down the way he did, even though he fell on his hands, the video showed? That's the word play. Well, geez, they debunked the glass. They debunked the falling on the shin, so it must have happened when he fell to the ground in that video. You see the video, ladies and gentlemen, his hands hit the ground, his feet, his knees, and his shins never touch it. It's a distraction, ladies and gentlemen. It's a false narrative. I fell to the ground. You saw the video, ladies and gentlemen. Multiple examples. This is again, we talked about this briefly. More wordplay. Twisting. Because they start from premise for that. Where is his hand there, ladies and gentlemen? It's pretty much near the center line. Maybe to the right, yeah, absolutely. And what did Bauer say? Oh, no, I have to go back and look at the cameras. Pixel distortion. Even their own expert, Stone, said, no, you're dead center, Corey, dead center. That's the easy use the word dead to tell you guys that. A fair witness wouldn't play word games like that, ladies and gentlemen. You shouldn't believe a witness who plays word games like that would evade the truth. And the judge already instructed you, if you don't believe part of it, you can disregard all of it, believe whatever part of it or not part you want. Timing and reaction is a huge part of this case. Whether it's 10 seconds that they want, whether it's 1.66, in this case, every officer, when they have are faced with a critical threat, they have to decide whether or not to respond in an emergency type situation. Davis, the new one say it's 1.66 seconds. I think Stone has it about 2.06 from the time of contact and walking around their efforts to the time the fire is done. Okay? Now, but the difference when officers go to training, you would be asked them about the shoot, don't shoot serious. You know they're going, hey, time to train, guys. They drive out to the course. And they know the concept is we do that. When they leave the house every day, they don't know they're going to be in an emergency situation. And nor do we, ladies and gentlemen. We don't know that as well. We all think we like to respond properly in an emergency situation, right? We had one of those last week, ladies and gentlemen. We had
response. That puts it in context, ladies and gentlemen. What officers have to do in this school, we have to do with our lives. How many times have you been drilled and trained on fire drill? Kindergarten, grade school, middle school, high school, church, work, different buildings you work in, colleges, they all have fire and training. We all think we would do well. No, there's no. But they want common drug discipline. They want common drug to take a position somehow, maybe involved in cars, so he's not aware, and somehow be able to see everything. And how dare you try to say what you can see or can't see? You put it in ladies and gentlemen, I showed you in the board here a divided attention. I had you focus on something. And half of you didn't see the drill when we talked about what happened or saw it. It doesn't mean that he saw any turning of the hands. It doesn't mean he saw a turn signal. And how dare they try to say that he did it? Story. Almost official. Just a couple of words. It's important. That's the first one. It's important. Cars, words, and actions. Okay. Everyone in this case, we talk about hindsight bias. We talk about your own, right? Everyone in this case testified with hindsight bias, except they put Connor Grove's statement because everyone else reviewed and watched the video ahead of time. Connor gave a statement. It's part of the protocol that they do between these types of officer involvement instances. Okay? Connor gave the statement he remembered based on that situation at that time. And you heard, especially you said, we don't think they're doing right away. She keeps saying too much later. They do it on purpose because when you're in a traumatic situation, you don't remember things correctly. So he gave a written statement, and you have it back there. And then the bottom of the statement, he says, I had the opportunity then to listen to watch the body worn camera and to listen to it. These are the things I don't remember. And he put the statement. How do you know he's telling the truth? Because under the prosecutor's theory, if you watch the video and audio, aren't you going to put down exactly what happened? No, he's so truthful and honorable that he gave a statement first. Then he said, oh, I watched it after an audio that asked you, this is what I missed when I watched the video of that. He's being a human being and honest and truthful. But they don't want you to believe his words. And they want you to try to believe that somehow he watched it first, then did it. No, ladies and gentlemen. They can wordplay all they want on that. That didn't happen. And important timing. Sescon was retained in grand jury. A year later, the case gets indicted. Remember what the special agent said about timing? All the reports he gets, no number, he read reports, the member severed, all this got to him. Connor Grove's words
Solve all the evidence before they testify, except Connor Rowe, they made him a witness.
Objection.
Overruled. Close the argument. Their witnesses. It's credible because it's consistent, it's confirmed, and it's the truth. And he tells you. I don't know how many people would say, yeah, here's what I missed. My statement that I now see. But they want to use that against him, not just as words laced out by his actions. What were his actions after the use of force? That he was forced in that situation after the use of force. Did he sit around and pummel over him? He ran as fast as he could to his thing to get the medics in, to put a chest seal on. He ran as fast as he could back. Those are his actions. Afterwards, she tried to run me over. You hear her point and say, yeah, I know. Duh. Afterwards, tells the fireman, yeah, do you have any injuries? Yeah, here, these, they're with him. He asks them, he shows them to you. Ladies and gentlemen, they took a video of life-saving measures, and they took a picture of an unborn fetus in an autopsy. No one's contesting how they died, ladies and gentlemen. And there's a reason they did that, ladies and gentlemen, because they don't have anything else. And they wrap it up in two professional second guesses. Because they started from a premise of it backwards. Now, we talk and we're here, no matter how much you can try to tell me in advance. In fact, the video's going to have on it, the picture's going to have on it. I can't do that. There were gasps. There were people crying. Absolutely. And you're human, and you should. Because that's real and wrong. That's what you should. But if you find yourself thinking about that, you committed things for the beautiful, take a breath and go back to the law and the facts. If you see another turn, keep saying that in their explanations. Law and facts. And there's two tables in the jury room, whether it's law and facts or sympathy, empathy, frustration, sorrow, sadness. That doesn't come into it. And we put you in impossible situations because you're human beings. You saw the corner test, like, oh, fast this. Doesn't matter. It affects us. How did we get here, ladies and gentlemen? How did we get here? We get here because they built the case on bias. They started with hindsight bias that Connor did something wrong. Legally, he was allowed to be. And every single police officer testified it was a proper tactic. They built their case on that. Why? Because they had bias from their main witness, the professor, okay, who testified at the jury. You heard what Miss Stevens asked, right, ladies and gentlemen? Pretty simple question. You think this is bias or not? How many times have you testified against the police officer saying that their force was not reasonable? 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15. 15 times. One, in the Clover case, there were two officers. Officer got shot to kill him. He still said it was an improper use of force. That's their person. Miss Stevens got to ask him about what do you think that's purpose is going to throw bias to the jury? No. Okay. The easiest question that was asked of him. Easiest question. Have you ever testified on behalf of a police officer in a criminal case? Zero. 0 times. Did you see how he tried to squirrel out of it? Oh, well, with these kind of constraints, with these kind of restrictions. It's a very simple question she asked him. Have you ever testified in a trial on behalf of a police officer? The answer, real easy, is no. When he says no, don't stand in the middle. How about answering, yeah, no, 0. Sorry, haven't. 15 versus 0. You don't think that that's bias? You don't think that that's starting from a premise of working backwards, ladies and gentlemen? They started, listed for them the four most important persons or witnesses that were pertinent to this case. Sergeant Moynihan. They call? No. The Kroger employee outside the car that you see. Did they call her? No. The suspect's, the deceased sister. Did they call her? No. The only person they called who was listed top four was Connor Rowe. They used his words and made him their witness. Ladies and gentlemen, there were 25 civilian witnesses that were interviewed. They were interviewed, either they were in the store, in the area just outside the store, or in the area. 25. They put up a witness that was facing the wrong way and didn't see anything, but heard something. Doesn't know what she heard. She heard someone loud stuff, and then she heard a shot. That's the civilian witness they put up. Because they pick and choose, because the other witnesses don't match their starting from a story backwards. The person that the most time this guy was Sergeant Moynihan. He didn't want to have a full picture of the involved. Mrs. Stevens told you in opening that this is basically the whole thing of the case. Let me just go through this. The immediate threat of officer or others who serves physical harm or death will permit to respond with deadly force. That's the question. That's the theme. The next paragraph, you read it to yourself right now. That's in your jury instructions. Word for word. Tactical risk. Tactical benefit. Unjustified risk taking. Least intrusive. None of that in your jury instructions. None of that. None of it. None of it. You know what will be in your jury instructions? The Graham factors that the judge already read to you. The severity of the crime, immediate threat to the safety of the defendant, the police officer, others, active resisting or attempting to obey the rest by play. There's a reason they're in there, ladies and gentlemen, because it's the law. Their own expert doesn't even cite the law or tell you about it. He uses different phrases to couch it. And you just go, why? Why, ladies and gentlemen? Why would he do that? Because they now want to say, oh, because there's a policy, because there's some kind of policy that, that's no, there's no, and you know what? They're all witness. Okay, put on to get the policy into evidence that they're going to redact and show you was asked, is this a violation of policy? Their own witness said no. He's lieutenant in charge of it because it wasn't feasible for him to get out of the way. Their own witness. Again, their witnesses collide with one another. They don't care. If something doesn't fit the quadrant or if they conflict, ladies and gentlemen, that's not proof beyond reasonable doubt. And it definitely shows that we've proven more likely than not our burden. Every officer testified. Lieutenant Rutherford, when they were part of Peter First, list of officers, Sergeant Moynihan, and it was reasonable. They all told you to use force when you see an immediate threat, and they told you the car hitting you was an immediate threat. Why? This is what I told this to you. Why? Then, figure it out. The last question they asked their professor, their legal scholar, their last question, ladies and gentlemen, it was the only time that he was scholarly, honest, academically honest, policing expert honest. And I was shocked when I heard the answer. So just be sure, I got the transcript. And I apologize, I have to put my glasses on. This is why, put Stephen in the shoes when he get hit by a car. There's only one verdict of it, and that is that our client, ladies and gentlemen, is not guilty because we have proven to you, one way or another, that it was reasonable to believe and that he acted reasonably. I thank you for your time. I thank you for your patience. I wish you Godspeed to your deliverance. Thank you very much. Thank you, Ron.
All right, y'all. That was the defense closing argument for his client. Yeah, that corner Grubbs. And to me, he did a good job. You know, he fed them states. He fed them states. He did his job. He did what he's supposed to do, and he did it. And the jury came back with a verdict of not guilty. Hope y'all enjoyed the Black Friday content. I will be. I should have put up a what you call it? Yeah, a target, but I didn't. But I guess I'm not used to begging. But so that was one of my Black Fridays. Let me put Takaya picture up here because I found a picture with her on it. Okay, let's see. Yeah, and here go Takaya. In case somebody said, "Oh, what? Who is Lanita speaking on?" Takaya. Sometimes you have to go back and you have to do your own research to know what the content creator is speaking on, and some things that we can't say, so we'll twist our words. Uh, those who don't have sponsors. So this is Takaya, y'all. Young girl made the unspeakable decision, and I don't have nothing else to say right now. Y'all like and subscribe. I'm out of here. But I'll be back because right now, like I said, I am doing my Black Friday nonstop contents. Okay? Hello.